है सेंटर और स्टेट के रिलेशंस। सो इसमें सबसे पहले टॉपिक है फिस्कल फेडरलिज्म। रिसेंटली सम स्टेट्स हैव मूव्ड सुप्रीम कोर्ट अगेंस्ट द सेंटर फॉर डिस्प्यूट्स ओवर शेयरिंग ऑफ फाइनेंशियल रिसोर्सेज बाय सेंटर गवर्नमेंट। Okay, so what is fiscal federalism? It refers to how federal, state and local governments share funding and administrative responsibilities within India's federal system. Constitutional provisions. 7th schedule Constitution delineates tax bases between union and state. Article 246. Distribution of revenue. Classification of tax revenues between union and state is as follows. Tax levied and collected by center but wholly assigned to state under Article 269. Levy and collection of GST in course of interstate trade and commerce. Article 269A. This was added by the 101 Constitution Amendment, which is distributed between center and state on recommendation of GST Council. Taxes levied and collected by union, corporation tax, personal income tax, central GST, etc., and distributed between union and state. Article 270 on recommendation of Finance Commission. Basis of devolution. Vertical devolution, share of states from divisor pool, which presently stands at 41% based on the recommendation of 15th Finance Commission. Horizontal devolution, it refers to distribution among the states from shared allocated to states based on various criteria. As per 15th FC, the criteria and their weight are income 45%, area 15%, population as per the census of 2011 15%, demographic performance 2.5%, forest and ecology 10%, and tax and fiscal efforts 2.5%. So what is income distance? Income distance is the key criterion used by Finance Commission of India to determine distribution of tax revenues among states. It measures how far a state's per capita income is from state with the highest per capita income. The state with the highest per capita income serves as the benchmark. The income distance of a state is calculated as the distance from its per capita income and the benchmark state's per capita income. States with lower per capita income receive higher share of central tax devolution to ensure balanced economic development. It promotes equity, helps in reducing disparities between rich and poor states, guides tax devolution. States with lower income levels receive more financial support from the center, encourages development, aims to uplift lagging states by providing them with resources. For example, if Maharashtra has the highest per capita income and Bihar has much lower per capita income, Bihar will get a higher share of central tax revenue based on the income distance formula. Okay, then what is grant in aid? Center provides grant in aid to states as per Article 275. Okay, borrowing. As per Article 292, Union government has power to borrow money either within or outside country, while under Article 293, state government can borrow only within India and not abroad. And if state is indebted to union, it may not resort to further borrowing without prior consent of union government. Finance Commission is set up according to Article 280 to adjudicate sharing of resources between union and states. Status of state finances. States finance only 58% of their revenue expenditure from their revenue resources. Debt GDP ratio of states stands at 27.5% as per March 2023. Sources of state revenue: tax revenue, states own tax revenue, and tax devolution from center. States own tax revenue include taxes on income, taxes on property, capital transaction. Tax devolution from center: taxes on commodities and services. Then non-tax revenue include dividend and profit from PSEs, fee for administrative services, grant from union government, disaster relief, grants for local bodies, revenue deficit grant. Special category status was demanded by Bihar and Andhra Pradesh. SES is classification given by center to assist in development of those states that face geographical and socio-economic disadvantage. It was for the first time introduced in 1969 on the recommendation of 5th Finance Commission. In 1969, JK, Assam, Nagaland were granted this status. Later, Sikkim and Tripura were also granted. SES states used to receive grants based on Gadkil-Mukherjee formula. Constitution does not include any provision of categorization of any states in India as SES status. However, a wide range of special provisions are available to many states that have been listed under Article 371, 371A, 371H, and 371J. On the recommendation of 14th FC, this status ceased to exist and thus no SES has been granted to any state. Current special funding pattern to northeastern and Himalayan state etc. is on account of recommendation of subgroup of chief ministers and not as per their special category status. Criteria क्या होता है? Hilly and difficult terrain, low population density or sizable share of tribal population, strategic location along borders with neighboring countries, economic and infrastructural backwardness, non-viable nature of state finances. Special packages. Recently, CMs of Bihar and Andhra Pradesh had demanded special financial packages for their respective states. Special packages refers to support provided to state facing geographical and socio-economic challenges, offering them additional financial assistance and other benefits. Special packages are purely discretionary. They may be need-based, but the need is not the proximate reason for granting the special package. It is an additional grant under Article 282, which falls under miscellaneous financial provisions. Article 282 discretionary grants empower states, center and states to make any grant for any public purpose, even if it is not within their respective legislative competence. Sixth schedule. There is an increased demand for inclusion of Ladakh in the sixth schedule of Indian Constitution under Article 244(2) resulted from Bardoloi Committee's recommendations. It empowers governor to create autonomous district councils and autonomous regional councils in 6th schedule areas of state. ADCs consist of not more than 30 members and 4 are nominated by governors and 26 are elected. So this is not wholly elected body. At present there are 10 such ADCs in 4 states. ARCs cover a specific tribe within a region of autonomous district. ADCs and ARCs have power to make laws on subjects like forest management, agriculture, inheritance, marriage, social customs, etc. They have power to collect land revenue, impose taxes, regulating trading, collect royalties from mineral extraction, etc. Differences between 5th and 6th schedule. Applicability. Certain schedule areas declared by president in any state of India. Okay, currently it is declared in 10 states. Tribal areas of Assam, Mizoram, Tripura, Meghalaya. Okay, then administrative body, Tribal Advisory Council, and ADCs and ARCs. Powers. TIC being a creation of Legislative Assembly of states have limited power, which are mostly executive. Extensive powers including executive, legislative and judicial, all derived from Constitution. PESA Act of 1996 is applicable in 5th schedule areas but not in 6th schedule areas. Formation of new states. Recently, June 2nd marks the 10 years of formation of Telangana state. Article 3, provisions for formation of new states, alteration of areas, boundaries, names of existing states. As per this power, Parliament may by law form new state by separating territory from any state, uniting two or more states, uniting parts of states, and uniting any territory to a part of any state. Presidential recommendation. Such bill shall be introduced in either house of Parliament only on President's recommendation. Before recommending a bill which affects area, boundaries, or names of any state, President shall refer the bill to legislature of the concerned state to express its views within a specified time. Parliament can create a new state through ordinary legislation, that is by simple majority. Formation of districts. State government has power to create new districts or alter or abolish existing ones. Changes can be made by passing an executive order or law in state assembly. Beriberi Union case of 1960. Supreme Court held that power of Parliament to diminish the area of state under Article 3 does not cover cession of Indian territory to a foreign country. Indian territory can be ceded to a foreign state only by amending Constitution under Article 368. Consequently, 9th Constitutional Amendment Act of 1960 was enacted to transfer certain territory to Pakistan. State Reorganization Commission, S.K. Dhar Commission of 1948, which recommended reorganization on basis of administrative convenience rather than linguistic factor. JVP Committee of 1948 rejected language basis reorganization of state. Fazal Ali Commission of 1953 identified 4 factors for state reorganization, that is preservation and strengthening of unity and security of state, linguistic and cultural homogeneity, financial, economic, administrative considerations, planning and promotion of welfare of people and nation as a whole. Fazal Ali Commission recommended formation of 40 states and 6 UTs. Parliament implemented its recommendation through 7th Constitutional Amendment Act of 1956.